All right, let's break this down right now. I have two very special guests. I want to bring them both on, although I can only get a question from one. Right now I have Gene Rossi, our law and crime trial analyst, and also our other law and crime trial analyst and also host here on the network, Linda Kenny-Bodden. Linda, I'm going to start with you. Good morning.
Good morning.
Good afternoon.
Good afternoon, right?
So, Linda, question to you. You mentioned an interesting point about the self-defense argument as we were watching the medical examiner talking about the injuries. Can you elaborate on it for our viewers?
Sure. When Baptista gave his statement to law enforcement, and it was taped, right, for the jury, and the jury's going to hear it if they have not heard it already, he talked about self-defense, and he went through specifically what happened in terms of the beer bottle, that Mo Knight had a beer bottle. Now, at that time, he did not know what the forensic evidence would be. He did not know that there was going to be beer bottle shards found. He knew nothing about that. He did not know how the stab wounds are going to come out from the medical examiner's office. And to me, that adds a credibility issue for him. That gives him good credibility because the forensic evidence actually jives with what his statement was.
It'd be interesting to see if the defense articulates that so well like you did in their closing argument. But let's play a little bit more from the medical examiner. This is cross-examination, and if you haven't seen it, here we go.
These wounds to the body, wounds to the face, were there any wounds whatsoever consistent with being struck by a bottle?
All right, so let's go back now to Gene Rossi. Gene, you're watching this medical examiner. I like to say he's the share of medical examiners with one name, Dr. Boyko. What did you gain from this as you were watching both him under direct and cross-examination?
Well, I want to go back to Linda's great point, and it's not because she has the best pair of glasses in America. When somebody's interviewed initially, and Linda hit the nail on the head, they don't know all the forensic evidence, but his version of events squarely fits what Dr. Boyko is saying. And I got to tell you, this is very good news for the defendant, because Boyko is basically saying he wasn't punched, he wasn't stomped upon. That sort of shows that he was beat up. No, what happened is Mr. Baptista got hit with a beer bottle, and he was defending himself. And that's why there were just the knife wounds.
Okay, but Linda, you know, we talk so much about what the defense is doing here. You can't forget at the end of the day, this guy was stabbed multiple times. Right. There were three people involved in the fight, 2 people brought up on trial, so it's 2 against 1 here. The jury can't forget that. So how does the prosecution really amplify that point?
Yeah, well, the prosecution is going to say he died. I mean, simply put, he's, you know, he went up to the car, he died. But we don't know, you know, this is ridiculous that you have 2 against 1. But the defense is going to counter and saying, look, the autopsy of Mr. Knight also showed that he had flak in his system, that he had drugs in his system. He was big, right? He's a big guy, 200-something pounds compared to these 2 guys who are smaller, and they're going to say that the weapon just evened itself out, so that they were trying to get Mo Knight off Baptista, and then there had to be the stabbing with the 2 of them because he wasn't coming down. It's
really hard to understand what exactly happened. And Gene, you know, we only really have one eyewitness. We have Wendy Gambalis, the girlfriend of Muhammad Knight. I don't know if you've had a chance to see her testimony or even her testimony from the Elder case and how it matches up this time, but relying so much on her testimony by the prosecution, do you see any issues with that?
Yes, because she has a motive. Mo was her boyfriend, and she probably was very, very much in love with him, and she's probably going to try to slant her testimony to fit what she thinks the prosecution wants her to say. Now, I'm not saying that the prosecution coached her into saying exactly what she testified to, but she does have a motive and a bias for the victim. And if they're relying just on the girlfriend, I don't think that's going to work, because going back to Dr. Boyko, his testimony, I think, helps the defense more than it does the prosecution. And here's what Bob and I talked about and Linda talked about last week. Common sense, you can just visualize what happens. He got out of his car, Mo did. He went to the passenger side. He's a very large man compared to Baptista, and he hit him with a beer bottle. That, to me, is something that helps the defendant.
Well, that sounds like the argument if you're the defense attorney, because the prosecution is saying something very different, Linda. They're saying, wait a minute, forget this beer bottle. He was holding a red Solo cup. How much does this red Solo cup, the beer bottle, we've talked about it a lot, how much does that weigh for you?
Well, the Solo cup is important because they did find a Solo cup eventually. They didn't find it that night. They found it at the corner away from the car, and it could be argued that's the Solo cup. Obviously, they should have done testing on it. And the fact that Mo Knight did have defensive wounds on his hands. I think the medical examiner talks about some of the wounds he classified as defensive. Now, just because you have defensive wounds, however, does not mean that there wasn't an offense that caused you to get the defensive wounds. So, you know, it's really hard for a jury to try to say, what did happen that night? What did happen that night?
I don't know.
I
We're
don't
all
know.
trying to figure it out.
And
Linda.
if we don't know, how does the jury going to find beyond a reasonable doubt? That's going to be the issue.
We still got to see what the defense does, including maybe having their client take the stand. And again, we will be live in the courtroom tomorrow. Now, Linda, Gene, stand by. I'm going to be signing off. Bob Bianchi is going to be signing in. We're going to take a quick break, and he is going to guide you through the next chapter of this case. Stay tuned here on Law and Crime.
All right, welcome back to the Law and Crime Network. My name is Bob Bianchi. I'll be taking it to 3 o'clock. In the Baptista case, medical examiner testimony, very important. Let's go to court. Okay, so this is the Armando Baptista case. We have the medical examiner that was cross-examination by the defense, indicating there was no signs that he was beat up on his body, on his torso, on his back, on his arms, on his legs, no fractures. Linda, what's the relevance of this cross-examination?
Well, you have to put it in how this came in. The defense attorney started by saying there is no category for self-defense when you classify somebody being killed in self-defense. Natural, accident, suicide, homicide, the Nash syndrome, the Nash classification. So he's going by saying, look, you can have all this, you can have no beating up here. It wasn't there was a fight that was going on. What Baptista is going to say in this confession, he'll sum up, is that this is right. That, you know, he was assaulted by Mo Knight and tried to get him off him, and he wouldn't get off him, and only by stabbing him could he get him off him.
So this goes to a piece that we talk about a lot. It's not about just the evidence all the time. It can be about a lack of evidence in the case, and that's what the defense is bringing out
right.
here.
And then they're prepping the jury for the summation by saying, look, a homicide means you just killed at the hands of another, which just happened. That doesn't mean it's not justifiable. For instance, death penalty cases, when the state kills somebody, is considered a homicide. When the cop shoots somebody, is considered a homicide, but it may be justifiable. So they're going to prep that. This is all in prep for the summation. These are pieces that are going to fit in.
Right, and Linda, we talk about this all the time. It is all about the summation. Good trial lawyers think about the summation first, in my mind, and then go backwards in what they need to do to prove that in the case so that they could credibly say that before the jury. Now, we have another tape here of a very compelling witness. It's really the state's main witness in the case, and that's the girlfriend, Wendy, who was in the car. So you have the two defendants charged. You have the deceased, obviously can't be a witness, and you have Wendy. So let's take a look at what she had testified to, and we'll be back with Linda on the other side. Okay, so this is a testimony of the girlfriend, Wendy, who was at the scene. Her boyfriend, Muhammad, is the victim in the case, and she's describing it. Gene Rossi, we just listened to medical testimony from the medical examiner talking about no bruising. The defense was crossing, no fractures, you know, nothing on the body, nothing on the arms, nothing on the legs. And here she's describing a kicking and punching scenario. And I think this is difficult to reconcile with the actual medical examiner's testimony. What do you think?
Before I answer that question, I watched her very carefully. And what really bothered me a little bit is she had a lot of pauses. And I know it's an emotional testimony, but there were a lot of pauses where she's thinking. And if I'm the defense attorney, the medical examiner has no dog in the hunt. And he said there's no kicking and punching evident on the victim, yet she clearly states they both were kicking and punching him. If they both were beating the living daylights out of him, he would have had some bruises, some lacerations. That makes her testimony very questionable.
Right. And Linda, you know, I used to call this the mystery of faith, and I know we've all experienced this. As trial lawyers, we've watched two people completely believing what they're testifying to, yet they both can't be right. There's this human psychology to something like this. It doesn't necessarily mean people are lying. People jump to the conclusion it's a lie. Sometimes people deflect, make things up in their brain, and then try to justify it further and further as they're trying to explain the contradictions maybe with the medical examiner's testimony. Have you experienced that phenomenon?
Sure, and there's been a lot of research that 16 different people can see something and describe it differently because we're processing it differently in our brains. opinions, we have different viewpoints, we have different emotions when we're taking it in. That's why you rely on the science. So you rely on the medical examiner who says there's no bruising here that would indicate a fight. And you have to do things like that in order to see whose story is correct.
Okay, listen, in 5 seconds or less, you guys, when you go to summation with a case like this, I know it's hard to do right now at this point in time, but do you attack her as being a liar, or do you say she's just highly questionable, maybe overly emotional given the situation, has a horse in the race, but clearly, folks, you know it's not accurate based on a medical examiner testimony, or do you go for the jugular? What do you do, Gene?
I don't go for the jugular. Soft hammer. She loved him. She's very emotional. That was difficult for her. But members of the jury, with utmost respect to Ms. Gambolas, her testimony is completely inconsistent with the scientific data.
Right. What do you say, Linda?
Yeah, I agree with Jean. As a matter of fact, I would additionally say that on things she didn't know were going to be important, such as Mo Knight walked back to the car and she didn't know he was stabbed, she probably is telling the straight truth as she perceived it. But the other things she's seeing through an emotional lens, and they're not correct.
Yeah, excellent points. I would handle it exactly the same way. Guys, we are doing the Armando Baptista case. I got Jean and Linda with me, my two great guests that I have all the time. We got some great stuff coming up in the show. Stay tuned. We're going to go to a break, and we'll be right back. All right, welcome back. We're going to take a little sidebar here and talk about the new acting Attorney General Whitaker that was put in place by President Trump after the resignation with the force of the president of Attorney General Sessions, right? So I got Linda and Jean. You're here right now, and what we have in my ear, I hear Attorney General Sessions speaking. But let's before we get to that, this is really an amazing development. I have a lot of thoughts on it. I know you guys know this world really well, but let's watch, because this is a dramatic moment. For those of you guys who don't really follow this, you may look at this in the lens of politics, and why politics is involved in prosecutions in order to get to certain positions. I am a big believer that politics should be removed the minute you get in there, and that investigations and prosecutions should be black boxed and completely removed from politics. However, let's watch what I find to be a rather unsettling removal of Sessions, and as he gives basically his concession speech.
They said that since I had involvement with the campaign, I should not be involved in any campaign investigation. I have studied the rules and considered their comments and evaluation. I believe those recommendations are right and just. Therefore, I have recused myself in the matters that deal with the Trump campaign.
Okay, so this is what starts the whole ball rolling bad for Jeff Sessions. He recuses himself because of his involvement in the campaign after consultation with DOJ ethics attorneys. And this, in fact, is something that is standard, that if you're involved in a campaign and you have to actually investigate people that may have been part of that campaign, guys, this is basic stuff. You recuse yourself. There's not impropriety or the appearance of impropriety. Gene, you worked at DOJ for over 3 decades, and you know as well as I do that as prosecutors, we want to be above the fray from having our decisions attacked in any way by people that say that we're biased. Thoughts?
Bob, this is very personal to me. The Department of Justice was my home for almost 30 years, as you mentioned, and I worked on close to 10 attorney generals. And this acting appointment is not just unsettling, it's disgraceful. Not only is he wholly unqualified to be attorney general, in my view, he is a walking conflict of interest. And he is ejecting on the 5th floor of Main Justice, right down the street from where I'm speaking. He's injecting politics onto that floor. And they are political appointees, but you're right, Bob. Once they take office, they put a black box around investigations. And I'm worried that he is going to inject his opinion into the direction and the life of the Mueller investigation. That is horrible.
But Gene, just real quick, because we're going to get to that in a minute. My main consideration right now is Jeff Sessions' recusal, which was rebuked by the president. He was called everything in the book, up to and including Mr. Magoo, okay? He, in my estimation, did what the honorable thing to do was, regardless of whether you like Jeff Sessions or not. He had no choice but to recuse himself unless you're going to violate every rule, procedure, practice, and custom of prosecutors.
Absolutely. In the Deputy Attorney General's office, if not the Attorney General's office, is what they call an ethics czar or guru. And when he became confirmed by the Senate, Bob, he received an opinion from the ethics guru that you cannot be an Attorney General on this matter. And if he had said, no, I'm going to reject your advice, guess what? He would have been referred to the bar of the state of Alabama because he's violating conflict of interest requirements. So he had to recuse himself or he would lose his bar license.
Right, Linda, I mean, you're around the block with this kind of stuff. I mean, what are your thoughts? I mean, did he not, despite, again, what you think of Jeff Sessions, there were a lot of people who weren't happy with him, myself being one of them, to be honest with you. I think he put in some very draconian policies that brought us back a lot in terms of criminal justice reform. But nevertheless, I gave him integrity points for taking the heat like he did, doing the right thing.
Yes, and also I think what everyone has to understand is that these rules that are in existence, and Gene can confirm this, apply not only to an actual conflict of interest, but an appearance of a conflict of interest, much like we have in New Jersey, Bob, which are very strict ethics rules. So when Bob and I practice, we have to look at any case we take under the actual conflict or an appearance of conflict. And clearly there is an appearance of conflict here. There's no doubt about it. And the reason why you want to avoid people having an appearance of conflict, you want what they do as the Attorney General to be beyond reproach. You want what they do to be beyond politics, to be beyond personal vendetta, to be beyond revenge, to be honest.
Right, to be strict, call facts and law. Now, Gene, one last question on this area. When I was the county prosecutor, I was in charge of supervising every investigation and prosecution. If there was even a hint, a whisper in the political corruption cases we did that I even met the person, I immediately contacted the Attorney General and asked personally to be recused to avoid this very thing. Now, Sessions did the right thing but came under considerable heat here. You were in the DOJ for 30 years. While all that was going on, i.e. the recusal and all of the abuse that he sustained prior to his quote-unquote resignation, what do you think that did to the morale of those folks at the DOJ?
It was terrible. I worked in the main justice building, the headquarters on the 4th floor, for 11 years. And I was there during the Bush years, the Clinton years. And when there's a person in the Department of Justice who is accused of being political or over the top, it trickles down to the core, the psyche of the trial attorneys, the lie attorneys. And when I used to go on the road to Florida, to the Midwest, to New York, New England, I would suffer from comments about, wow, the Department of Justice really looks like a bunch of buffoons. And here's what hurts the most. The American people, most of them now think that the Department of Justice is a political machine under the thumb of the President of the United States. And that breaks my heart.
Right, and you know them not generally speaking to be that way, but when you get appointed to the head spot, like I did, let's be honest, we get there because of some level of politics. Hopefully there's competence involved in that too, but Jeff Sessions shut that spigot off, and I would think that the DOJ people, Gene, were respected him for that, even if they disagree with his policies.
You're looking at one right here. I wasn't a big fan of Jeff Sessions before he got appointed, but after he recused himself, I thought he was doing the right thing. He was an honorable man, and I got to tell you, I felt sorry for him when he walked out of the Department of Justice last Wednesday, and he was just canned, and he basically had a gun to his head. If you don't resign, you're going to get shot. I mean, I felt badly for him. I really, and he ended up looking like a class act.
Well, listen, I got to talk to you, Linda. I have been seeing more and more the infusion of those who appoint these officials, and I'm not just talking about federal, on the state level too, trust me, where politics is becoming the only thing there. They want their person. They want somebody to either use them as a sword or a shield, not to be a black box. When I got appointed by Governor Corzine, I'll never forget this. I thought it was kind of odd. He called me on the phone after I got sworn in and said to me, "Bob, congratulations. You were the best guy for the job. Make us proud. You'll never hear from me again." I thought it was kind of a weird comment, but boy, how that comment really has jumped to the forefront in my mind, because that's the way it should be done.
Yeah, and I like that. And let me talk about New Jersey a little bit. You know, we had, who Gene knows, Paul Fishman is a good friend of mine. He indicted Democrats and Republicans. He was a Democrat. Chris Christie, people don't like him, and I may not like them as governor, but when he took the office that you were in before, and as the U.S. attorney, he indicted Democrats and Republicans. He, you know, it was amazing, and people were at him. Other political parties were at him. How could you indict those of your same type?
Yeah.
Now it seems that that's what they want.
Yeah,
It's amazing.
It's frightening.
Frightening,
is
absolutely.
what it is, because we have a lot of power as prosecutors. Let's move on. We have the Whitaker. You know, he's out there prior to being jumped from the chief of staff's position. And Gene, I'd like to have you talk a little bit about how that succession is supposed to happen, where we have a compilation of clips with respect to stuff that he has said or written about Mueller prior to taking this job. Of course, Mueller now is the FBI person that's responsible to report to him for this investigation. Let's take a look. Okay, Gene, I want to go to you first. Can you give our audience a little idea of how the chain of succession is supposed to occur, and that this guy who's a chief of staff that's only been in there, I believe, less than a year, is now catapulted into the #1 position after having made comments like that?
My blood pressure has to go down a little bit after listening to those clips, but I'll answer your question. Normally, under apolitical circumstances, you elevate the Deputy Attorney General of the United States to be acting Attorney General. They did it in 1991 with George Terwilliger, who became acting Attorney General under the first Bush presidency. Eric Holder did it when he became acting Attorney General when Reno left. That is the normal way you do it. And I got to do a shout out. Rod Rosenstein, I worked with him. I was in Virginia. He was in Maryland. He is a class act and a very honest guy. They should have elevated him to be acting Attorney General. It is unheard of, Bob and Linda, unheard of, unprecedented, to put in the chief of staff to an Attorney General to make him the acting Attorney General. It is terrible.
Well, but Gene, can they do it? Was it lawful?
They can do it if you. I think it's not lawful because it goes to the appointments clause. I don't think he can hold that position under the appointments clause of the Constitution. If you haven't complied with that, then you go to a certain section of the regulations and statute. And under my reading, you should elevate Rosenstein before you put him as acting Attorney General. I don't think it's lawful. But even if it is, Bob, it's terrible.
Linda, to Gene's point before, there's something that's disconcerting about the idea that if you're doing an independent investigation, you have somebody who's already Senate confirmed in Rosenstein. He's a person who's been intimately involved in this investigation from the beginning, knows the ins and outs, the permutations, doesn't have to catch himself up. Wouldn't anybody looking for good government continue to use that individual as opposed to bringing somebody in who's going to be subject to complete attack because of the previous statements made, questionably put into that position, and who could have a political bias? I'm sorry, is that a loaded question?
That's a loaded question, but let me answer by a quote. I don't want to get it wrong. Justice Thomas last year, when the General Counsel of the NLRB was just appointed, they said this was not appropriate because there was a serious risk of abuse and corruption if one person fills an office. And really quickly, Bob, Whitaker is going to say, I didn't say those things. I didn't say that I had prejudged it. I said that there was no evidence that now, and that's why we needed an investigation. But I didn't say I prejudged it. That's what he's going to say, Bob.
I think that we could all talk about this till the cows come home. This is problematic because you know what? It also sets a tone for prosecutors throughout the entire nation, federally, state, and even local. Like Gene said before, these things have a trickle-down effect, and this is not a positive one in my mind. Listen, we have so much going on here. We got another special segment that's going to happen, actually two specials, I believe. Don't forget, flip that script. And we're going to be on a break, and we'll be back on the other side. Okay, welcome back. We got 2 minutes to discuss this, Linda and Gene. So, Linda, I'll start with you. he's bringing out contradictions in the statement that she gave to the police, and what's probably worse in my mind is she's saying that she did tell the police things that are not noted in the police report. So it's almost like she's going against the police reports. Thoughts?
Well, but the problem is that if she told them things and the cops, they just omitted from the police report, that happens all the time, as we know. But when she tells them something that the cops specifically say she told them something different, that's a problem.
Yeah. Gene, what are your thoughts about that? I mean, don't forget that this whole thing is really odd about that the defendants rather leave this party because there's some acrimony going on, and somehow afterwards, Mr. Muhammad and Wendy are driving behind that vehicle at a stop sign, and the story here is that Muhammad got out with this solo cup in his hand because, in the middle of the night at a stop sign, what's better to do than go out and say, hey guys, how you doing, and shake their hand after there was supposedly some problem with them before, and now you have these contradictions. Not good for the prosecution.
Bob, it goes back to what you said, I think, a week ago. The common sense test doesn't make any sense. They stop the car behind the defendant. He gets out and he's holding a red cup. Why are you holding a red cup? He got out because he wanted to beat the living daylights out of Baptista. And you're not going to hold a red cup as you get out of the car. You may hold something else like a beer bottle, but not a red cup.
Right, and when we watch how a defense attorney is doing a very good job at constructing a case here, when you add the common sense contradictions of this testimony, and then Wendy's testimony saying about the beating that he took, but a medical examiner saying there wasn't really any indication of a beating, the defense attorney is heading on his way to a not guilty. We're going to break. We'll be right back. Okay, so welcome back to Law and Crime Network. We are now back to the Armando Baptista trial. We've listened to medical testimony today that indicated that there was no bruising on the back or the front or the arms or the legs, which is inconsistent with a fight, which is what the victim's girlfriend, Wendy, had testified to. Wendy was cross-examined about contradictions based on information that she gave to the police. But this case essentially comes down to, was just this an innocent encounter, or was there an argument that occurred? Armando Baptista and Eldridge decide to leave that location, and then Muhammad comes up behind them. Was it a friendly gesture? He gets out to shake the hand, as Wendy indicates, or was this really an attack? Let's go to see how the defense is doing a really good job at putting this all together. Linda, you would agree, right?
Yes.
So far, it's good, but it all depends on how they're going to be able to piece it together in openings and summation.
In openings and summation, and also evidence. We talked before about and we discussed it previously before the break, how there was no bruising. The medical examiner said, Dr. Bianchi. But then if I were the prosecution, I'd bring in an expert to say, hey, just because I land a punch, as I just did on you, Bob.
That is
okay?
like every show.
Every show
Every show
just
I
an
have
assault,
been assaulted.
Right? It doesn't necessarily leave a bruise. You're not bruised.
Right. Yeah,
so,
but Muhammad and Baptista and those guys weren't there to give them each other a little patty cake. Anyway, let's go to the defense opening. Okay, welcome back. All right, guys. This is the cross-examination going on here, and obviously the defense is trying to point out, I'll go to you first, Gene, this issue about Corey. Let's start. This is based on a previous incident that Armando has allegedly had, Baptista, where he cheap-shotted this guy, Corey, and I think maybe fractured his jaw or his nose or something of that nature. And what's being said here in cross-examination through this witness, Syed Ali, is that Corey calls Muhammad to come over, that's the victim in the case, come over to this party, and then there's this weird encounter where his mood changes. This is good defense information because it's completely supporting their case, no?
Absolutely. Now, are you sure that this is cross? Because that sounded like a direct exam by the defense attorney, but what do I know? This sort of buttresses what the defense attorney said in her excellent opening about how there was an awkward moment when Mo walked up to Armando and asked Armando his name. That corroborates that Corey called Mo to come to the party to be his henchman.
Right, and it would also fit right into the defense's theory that after this encounter, the two defendants that the state decided to call defendants leave because they know they got to get out of Dodge. And what happens next? The guy who was called to the party leaves the party and follows them over to that stop sign. Fits right in the puzzle piece of that picture for the defense. No, Linda?
It does, except, Bob, I am totally confused because I don't know why the state would want to call somebody to talk about a prior incident where their victim punched somebody out and changes. I don't get it. And then, and also, Mr. Ali said he wasn't paying attention after all the testimony comes in, so why is he on the stand in the first place? And also, there was objections to what he saw based on its testimonial. Of course it's testimonial. He's testifying to what he saw, and the judge is saying it. So I am totally confused.
Yeah.
Confused, and confused.
Yeah, but nevertheless, it's good information for the defense. And the point that you're trying to bring out, we were kind of all aghast when we were listening to this, was when the lawyer is asking, did Corey point out the victim in the case to Mr. Muhammad?
Right. There
was an objection on hearsay. Hearsay is an out-of-court statement used to prove the truth of the matter asserted. The judge sustained the objection. We don't get that. He was actually just pointing out what was going on, and that's a big piece of evidence. But nevertheless, the jury heard the question, even though the judge didn't allow the answer. We got to run to a break. We'll be back on the other end. Welcome back. Hey, Gene, I think she did a really effective job. Now, a lot of times in a defense case, you don't get that much into the specificity thing. She laid it out. She was calm. Her cadence was good. I think the jury is going to like her. I think she's appealable. And she got right from the beginning, set their theory of the case out, gave them the law on it, and was confident to go in that jury room. You'll come back and say not guilty. What do you think? How did you think she did?
I give her an A, and here's why. In an opening statement, if not in a closing, you try to tell a story, the final mosaic, what the picture at the end will look like, even though a mosaic is tiles. And what she did, she didn't go through each witness seriatim like the prosecutor did, which makes the jury's eyes glaze over. She just told the story based on what each witness will say without identifying what each witness will say. And that's an excellent way to do an opening. The other thing she did, she didn't use that polenta phrase, the bromide phrase, the evidence will show, the evidence will show. She just did it a couple of times. And at points, I thought she was doing a closing argument. Which
Right.
is a good opening.
You know, Linda, Gina, myself, and yourself have talked about this a lot. As a prosecutor, if I can, or for any attorney for that matter, even as a defense lawyer, if I can get away with doing a closing in my opening statement, I'll do it to the best extent possible. And as Gina indicated, she peppered in there,
Right.
the evidence will show, but not overly so, to avoid the objection. What were your thoughts of how she did?
I thought she was fabulous because in the first paragraph of her talking to the jury, and she's talking to the jury, what does she say? She sets out her defense so they know where she's going. Remember, ladies and gentlemen, Bob, every trial is a production. It's no different than going to a Broadway show. You want to know what you're going to see.
Wait, ladies and gentlemen and Bob, are you somehow separating me from those two categories?
You're above here.
Or was I
Bob.
part of both of those categories?
You're above us, Bob. You're fabulous.
No, I agree. You got to let the jurors know as much as you can so that the testimony makes sense and it fits in. For example, just a perfect example about, was there a solo cup? Was it a beer bottle? Was it a friendly gesture? Well, evidence is key in this case, and so crime scene processing is going to be important. And Lisa Cruz was a crime scene person who testified for the state, but man, there were mistakes that were made during the course of that investigation. And usually you got to find a way to either cover up or go back and do an evidence review early on in the case to see if you missed something. Let's take a look at Miss Cruz's testimony. Armando Baptista trial. This is Lisa Cruz, a crime scene processor. Seems like Jean Rossi, a lovely, lovely woman. But I have to ask, did you not prep? Do you not know? I don't recall. You're a crime scene investigator. Did we take fingerprints on the outside door handle? Defense is asking that because of did the victim in the case grab the door handle? Blood inside the vehicle? I can't recall. Glass inside the vehicle, which would be consistent with being the beer bottle? I can't recall. Well, let me show you a picture. Oh yeah, there's glass. It's the beer bottle. Is this just completely non-prepped, or does she know it's bad, so she falls on the sword of the I don't recall refrain?
Okay, all I can tell you is this. This is a high-profile case, obviously, and I would have prepped this witness probably 4 times, and I would say, listen, I want you to do some homework. I want you to read your file 3 times because you have to know it by heart. I have had acquittals and hung juries because my key law enforcement officials were absolutely terrible. And sometimes you can prep a law enforcement official, and when you get on the stand, they just have the deer caught in the headlights. I don't think this person was prepped, and shame on the prosecutors.
Right. So, Linda, when I prepare for trials, as you do, we look at all the areas that the other side is going to cross-examine and try to at least prepare the witness or ask, like, why didn't you do this? How come you didn't do that? The answers are what the answers are. You never tell a witness not to say something, but they at least target harden them and say, this is where they're going. Just want to let you know. It didn't, like the I don't recall thing on whether there's blood.
I know.
We're not talking about whether there was like something that's insignificant. We're talking about blood. You're a crime scene investigator.
Yeah, and remember, every victim is important, no matter what, because at the time before they go to trial, you're saying they are a victim. And if you're not doing the things that are going to help get a conviction or at least bring justice with a not guilty, why are you even at the scene at all? And I expect what she will eventually say is something to the effect of, well, we don't know what, we only do what the detectives tell us to do, or we only send for testing what the detectives indicate, and I don't have access to that, or something to that effect. It's nonsense, not common sense.
Well, yeah, you get a carryover factor when your investigators don't do a good job, can't recall not doing a good job, but I guess most importantly, he got that there's blood in the vehicle and there's glass, a beer bottle shattered inside of that vehicle. So substantively, the defense scored huge points. Stylistically, they scored huge points with that case. Maybe the reason why there was a not guilty on the manslaughter of the co-defendant's case. We got to go to a break. We'll be right back. Okay, so that's Wendy Gambolis. She is the girlfriend of the victim in this case. You're listening to her testimony with regard to how the encounter occurred at the cars. Now, Gene Rossi, 3 decades, the DOJ, hashtag 4041 for all those points you shot back in high school. I would define this direct examination in the category of pulling teeth.
It's tortured, and it goes back to the pregnant pauses. I always told jurors to watch the demeanor of the witness, and not just what they say, but how they say it. And I get the feeling, I'm not there, but I can sense it, that she's kind of making a little bit of this up. It makes absolutely no sense that they stop, he honks, and he just gets out of the car and he says, I'll be right back. And he didn't say anything before that, and he casually walks up to the passenger side and stops at the gas tank, which is on the left side of a car, by the way. And this other guy gets out, Mr. Baptista, and leans against his door. That makes no sense. It makes no sense.
Yeah,
Not only the red cup makes no sense.
Yeah, Linda, so
Yes.
the one thing she was able to do is offer gratuitous stuff, like when she wasn't being asked. She couldn't answer the questions that were being asked. And I feel bad for the lawyer because it's a tough witness to handle when you have to pull teeth like this. But she kept repeating, well, he's calm, cool, and collected. He grabs his solo cup. We'll get to that in a minute. And he was going to see a friend. Well, these people aren't friends.
Yeah, and
there was an encounter that occurred previous to this.
Right.
That's why those 2 guys left. So, and then he wasn't aggravated. She gratuitously put that out. And then we go through this whole thing. He gets out to meet. He's standing there. Then no, he's not standing there. He's approaching the car. She's all over the place with how this encounter initially starts. Now that could be out of just fear
She's
or
upset,
panic or
too.
upsetness or what have you, but she's not making a good witness for the defense.
And
for
you
the
know,
state, rather.
I look at our chat room, and Florida residents said they find it hard to believe, that there wasn't a punch, but that no way believes that that night went up to the car as a friend. As none of us do. We think that in terms of common sense or nonsense, that's probably nonsense. And then somebody else indicated, well, there probably was some punches as Baptista's trying to fend the bigger guy off. That's common sense, right?
Right.
So yes, but you know, you have to understand, she did see her boyfriend basically killed, even though he wasn't dead on the spot. He was in a terrible fight. So I give her a little bit of room. But when a witness says, well, honestly,
Yeah,
for one question, you then have to wonder what she was thinking of the other questions, whether she was just not making it up, but that she wasn't sure, so she was answering like she thought she saw something, but maybe she didn't. So but also the prosecution here. I mean, the prosecution said, well, what do you say? It's like, you're staccato in a typewriter. Ma'am, what happened when you saw Mo get knifed? You and your voice can have a different inflection, too.
Right, and Gene, to the question you asked me on flip that script kind of, and we'll reverse it and put it into this scenario. I mean, you know your witness's strengths and weaknesses if you're preparing your case. And as a prosecutor, it is imperative, because of direct examination, and maybe you can explain that to the audience, that you get your witness to say, I can't do this on the witness stand. You need to narrate the story. And you got to work with them. It didn't seem to either be happening here. If it did, she's just really a poor witness. But to Linda's point, you should be able to tell the most intense thing that's ever happened in your life without having to be pulling that teeth to get it out.
And Linda brought up a good point. The skilled prosecutors, and I'm talking to two, I think I was, you have to live that moment with your witness. You have to use that extra sympathetic voice that Linda just talked about. Don't be antiseptic when you ask the question and say, what happened next? Or what did you see? Put a little thought and emotion into your question, and goes back to prep. If I had a witness like Wendy, I would have gone through her testimony probably 4 times so that she even knew what I was going to ask next, so that she wouldn't have these gratuitous comments. It's like he's going to see a friend. That actually really hurt the more I think about it.
Yeah.
That was extremely gratuitous.
Yeah, and she doesn't answer the question she's being asked, and it's gratuitous, and it doesn't make sense based on the other evidence. So I don't know if it's witness preparation or whatever, but I've had witnesses like this, and I've worked with them extensively, not telling them what to say, but how the delivery's going, practicing it, going over with them so that they can narrate the story. That certainly didn't happen with this witness. Let's go back and listen to a little bit more for testimony. Okay, so that's Wendy, the girlfriend, Gembalis, who's testifying in this case. Guys, let's get right to it. We have a short period of time. I just have some of our chatters in our great chat room. FL, Florida resident, says, the lack of emotion is very strange. Funfree says, there's truth and lies kind of woven in between. As a juror, they would dismiss this testimony. I just want to get into a little bit of what we talked about before, guys. I mean, they're asking specific questions about distances and heights and things like that. I mean, she can't even get that right. Like, why would you as a lawyer be asking these questions if your witness didn't know it? And if your witness does know the answers and can't deliver them, something about this sounds really shady, consistent with what these people in the chat room are saying. I'm not saying it is. Linda?
Yeah, and they're being asked, she's being asked about how big the passengers. Well, the person is on trial for being the passenger sitting right there in the courtroom. And they had 2 trials. So, number one, if she gets the height right of that person, then, so what? She's been watching him. And if she doesn't get it right, then it's ridiculous to begin with.
Yeah, Gene, I just find that, like, consistent with what I think our great jurors in the chat room are saying, both in substance as well as presentation, they're not, if they were a juror, they just weren't going to rely on this testimony.
The chat room people are brilliant. The lack of emotion, I call it the pregnant pause, and she's rolling her eyes. I swear to God, she's trying to think of details that will help. But I got to say this, I'm so glad that this man is not 8'1". That would be a tall basketball player.
Yeah, you wouldn't have been scoring that hashtag 4041 if you were going against an 8'1" basketball player, Gene Rossi, the great war room, Gene Rossi. Guys, we got to go to a break. I'll be back with our great guests on the other end. Okay, howdy. We're in the Baptista case. The producers are going to give us a little more time. Gene, Linda, I had to ask for more time on the last segment that we did because we got some great questions from Window Watcher, and I want to address them because, again, this is our jury out there. Did she call 911? Now, we don't believe she did. We believe she called Corey. Corey was the one who was supposedly assaulted by Baptista earlier. Corey is the one who supposedly called Muhammad, the victim in the case, to come to the the party, and Muhammad had this encounter with Baptista, and Baptista and his friends say, let's get out of here. And now they're behind the defendant's car in this encounter. And Window Watcher asked a very interesting thing. Could she be shading this testimony? Could we be listening to this kind of wobbliness because she sees herself and trying to get herself out of being an aider and abetter and driving the car to this confrontation? It's a great question, Linda.
It is a great question. I don't know the answer to that, but yes, could she? If she sees something in there that she eventually could be charged that she knows about, sure, she could be shading her testimony. I hate to say that, though, because she did watch her boyfriend get stabbed, but when she calls Corey, you know, when she calls more muscle,
Yeah, you know, there's a lot there. Gene, what do you think about that? I think that is a brilliant observation by Window Watcher.
That juror on the blog is brilliant because it's what Linda said. She didn't call 911 worried about her boyfriend. She called the person who was beat up by Armando, and that gets the motive. That's why they followed that car and stopped at the stop sign. That's very bad for the prosecution.
Yeah, I mean, that is a very good observation. You know, this is why once a lawyer said to me one time, and it's so true, that the collective intelligence of 12 jurors making a decision stymies any one individual lawyer, no matter how smart you are. They see things in that perception. You gotta love this chat room. Thank you so much, Window Watcher, for that great question, and all of you, and for all your support. So, I'm fascinated by the defense here. They're really putting on a strong case, and they have a good case to put on. Let's listen to the defense opening statement. All right, so that is the defense opening in the Baptista case. Gene and Linda, this is reinforcing the themes we're talking about. This defense team is doing a really good job. Talk about opening the door. That gets to them asking questions of the crime scene investigators. Did you even think to take, you know, the fingerprints and do that properly? That he didn't get out of the car. That gets to the point where, even though the crime scene investigator didn't seem to know whether there was blood or glass inside the vehicle, there was, and that's consistent with the defense theory of the case. And I love that little phrase that she says, what they didn't know, referring to the defendants, was that the victim and the girlfriend were following behind them. And it kind of gets into, again, I can't say it enough, Window Watcher's great thing about the aiding and abetting. The pieces of this were done right from the outset in the opening statement, and that defense attorney is putting meat on these bones. Linda?
Yeah, and you know what also, Bob? Remember, the defense had the benefit of the first trial, the co-defendant, where initially, remember, these two were charged with murder. Then the grand jury downgraded the co-defendant to manslaughter, and then the prosecutor downgraded Baptista to manslaughter, if I recall correctly. And then the co-defendant, Elder, gets tried, and he's only found guilty of the basically a misdemeanor, and got time served.
Right. Maybe we could show that graphic that was just up there right now, if our producers can pull it up, of when the verdict comes in. Gene, we talked about this before. You see the look on his face. He got out of the charge that could have put him in jail for an extremely long period of time. Nevertheless, he gets convicted of a misdemeanor offense, which essentially is going to be a time served. I don't know if we can get the graphic, but you remember it. He hangs his head down, and we were kind of luckily it's right there. Thank you, producers. Great. Look, it's almost one of not exhilaration or joy. I'm not going to state prison. It's one of disgust, sadness that he can't believe he actually got convicted. Take a look at that face. Just hanging his head low, and then eventually he gets handcuffed, even though he knows right there, I am walking out of jail because I've already served my time on this case. Look at that sadness, if you will, shaking his head. What do you think about all this, Gene?
We discussed this last week, I think. He went from murder to manslaughter to conviction of a misdemeanor, and he's still distraught about it, and here's why. He knows that Mo tried to kill Baptista, and that this man, D, they did nothing wrong. They were at a stop sign, and this big guy gets to the right side passenger and tried to kill his friend. And he did nothing wrong. That's what that looks like.
Guys, 5 seconds or less, give me an idea. Why do you think the jury, based upon all the evidence, if they were not convinced that they were the aggressors or that there was really a self-defense scenario going here, that's the only way they can get to that conclusion, why the conviction for the misdemeanor? Compromise, verdict, Linda?
Compromise him because somebody died, and they figured, well, you know, maybe he could have avoided just stabbing him. I think the testimony was that Elder stabbed once, then gave the knife to Baptista, if I recall now. That's in this trial, and the Baptista stabbed, but just because somebody died.
How about you, Gene?
I totally agree. Compromise. compromise, and they wanted to reward the prosecution for going forward.
Wow, that is something else. I'm a big fan of if the facts don't support the charge, I would have held out personally if that's what I believed. Convicting somebody for an offense that you don't believe they committed is never good. But compromise happens all the time in these cases, let's be honest. Guys, love having my two great guests. This is really a great trial. Law and Crime Network knows how to pick them. Check out the Pluto TV app if you're not on it. I'm using it all the way in here on the train. Usually when I'm delayed, I can at least watch what's going on. Or go online to lawandcrimenetwork.com. You can watch us there and get into the chat room. Going to a break. We'll be right back. Okay, welcome back. Well, Peluso had testified earlier, and there were problems with regard to remembering things, and she kind of basically was like, hey, I just give the stuff over to the crime scene lab people. But right there, she's pointing out a glass bottle, and that is later going to be used by the defense to say it is a beer bottle, and it clearly is a beer bottle to any ordinary person looking at that. And that is right at the incident where this crime took place. There's an argument here from Wendy that Muhammad took a solo cup, and that's it. Nevertheless, there's a broken beer bottle. Linda, what's the significance of this?
Well, because what the defense is saying is that Mo Knight actually attacked them with a beer bottle. He was inside the car and then outside. And therefore, that's why they got into the stabbing. So it goes along with the story that the aggressor was Mo Knight and he had a deadly weapon, which is a broken beer bottle.
Yeah, but what would be the importance for them to put on testimony that there was a broken beer bottle at the crime scene?
Because the girlfriend says that all he had was and we're laughing, but it's true. The girlfriend said all he had was a red Solo cup, which is a lot different than a beer bottle when you're talking about weapons.
Okay, so Gene Rossi, we have Armando leaving the scene, basically him and the co-defendant. A bad encounter going on here. We got to get out. The next thing we know, Wendy and Muhammad are in a vehicle, quote unquote, following them, or at least taking the same path. And while at a stop sign, he decides to get out with a Solo cup and say hello to the guy and shake hands that he had just shake hands.
We're shaking hands here.
The hands he had just shaken before, and lo and behold, there's a broken beer bottle there.
You know what? Last Saturday, I was at an intersection, and it was almost a road rage incident. And there was a tiny fender bender, but one guy got out, approached the car in front, and there were fisticuffs. I watched this for like 4 minutes. You don't get out of a car and walk up to the passenger side just to say hello and shake their hand. That makes absolutely no sense. But going back to that bottle, if they didn't fingerprint that bottle, that is horrible police work. Horrible police work.
Yeah, and Gene, we know right now from Officer Peluso that there's a broken beer bottle outside the vehicle. If you recall the testimony of Wendy, this altercation is happening when they're both outside the vehicle. So if that were, again, using your common sense, you don't need to be a scientific genius like Linda Kenny Bodden is and her husband to know there shouldn't be blood and glass inside the vehicle. Let's watch the cross-examination of the defense attorney of one of the crime scene investigators, Ms. Cruz. Okay, so Gene Rossi, right now, if I'm at counsel table and I'm a prosecutor, just for the split second that I would ever let my mind go away from anything that was going on inside the courtroom, I'd be asking myself, how big a bowl of pasta and meatballs can I eat tonight to take my mind off of this? Because either I didn't properly prepare my witness, shame on me. This is a manslaughter case. They wanted a murder case out of it. And it's a crime scene photo of the vehicle with glass that's now on the outside and on the inside and blood that's on the inside. And that blood on the inside belies the state's entire theory of the case. And I have a witness saying, I don't recall, and then being shown photographs, oh yeah, I guess there is broken glass in there, yes, there is blood in the console, so on and so forth. So how big a bowl of pasta, Gene Rossi, would you need to eat after this testimony?
My wife, Diane, is actually making spaghetti and meatballs tonight. I would have 3 helpings after listening to Officer Cruz, but I want to talk about fronting as former prosecutors. When you have a witness for the government, even for the defense, and you know there's negative stuff that they can bring out on cross, this should have been fronted by the prosecutor. They should have brought out in direct testimony of Officer Cruz that there was glass, there was blood on the seat, there was a bottle on the road. They should have brought this out, because the jury's is probably looking at the prosecutor and saying, hey, why didn't you tell us this on direct? That's what's going on with that jury right now, and they're losing faith in the prosecution.
Yeah, I agree with you completely. Linda, is it possible, and I'm going back to window watchers.
I'm writing this question down.
Window watchers' theories here, which are good. Is it possible that perhaps he went outside with a beer bottle? I mean, you can't get around the evidence. Not a soul. I'm just saying, is it possible? And that the state could argue the case that maybe there's some, kind of covering that little piece up, but it still didn't give them the right to kill the man. Is it at least possible the beer bottle broke during the course of the altercation when they were attacked? I mean, to Gene's point, you got to give it up somehow, right? It's there.
And is it possible, I mean, when you're investigating this case, to investigate whether the defendants actually had the beer bottle and that was the weapon that got involved in this? Anything is possible. It is possible that Bob is going to strip right now on there, but it's not likely.
Well, I'm not going to do it because Nellie in the chat room is calling me the Italian stallion. So I don't need to diminish myself in front of her. I hope it's her. I don't know, whatever. But listen, guys, you are doing great in that chat room. We really appreciate it. Deanna, thank you, and Addie for all the work that you do. And Kathy Russins in the background giving us data that we need, and the producers in the room getting those clips up when I kind of shoot it at them without any forewarning. You don't get any better gavel-to-gavel coverage than this. Breaking a case down like this with pros like Linda and Gene is huge, because the lawyering makes a big difference, and the manner in which the case makes a big difference. And guys like this can tell you how they would have done it with the same exact facts, and hopefully myself too. We're going to break. We'll be right back. Okay, so that's the prosecutor's questions. Now, let me give the audience a little bit of what I understand about this trial. The red cup is still a mystery. We're going to show another clip about this red cup. But one thing we know about this red cup is it was never submitted for any kind of analysis. And you know what, Linda? Another thing we know is the beer bottle, which was collected and sent for DNA and/or fingerprint analysis, it was never performed. Now, what happens here is an evidence review, and usually the prosecutors or detectives make a decision as to what will be analyzed and what won't. And when you are dealing with a lack of evidence or a failure to do something that you should do, and this is such a big issue for the prosecution, and their witnesses saying, no, he walked over with the solo cup and not the beer bottle, I think that creates reasonable doubt in and of itself, the failure to do scientific testing. This is the world of NCIC and all the crime scene shows, and there's no way jurors are going to like that.
And this is my world, right? You do scientific testing. If you are the prosecution and you believe that every death is important, as we had here, you don't know what's happening. You have to investigate it with your officers. You have to go through it with your officers. You have to do what you think is right. Now, if the prosecution didn't think it was right that they shouldn't need DNA testing and fingerprints because they really had a lack of belief in the story here because they downgraded from murder to manslaughter, then they should dismiss the case.
Yeah,
Don't go forward with it.
I don't disagree. Gene, the grand jury's the one, as I understand it, that went from murder to manslaughter, which is just kind of amazing in and of itself if you know anything about the way a grand jury functions. But I'm asking you, I want you to put your thinking cap on. There's a war room dedicated to you, the Gene Rossi War Room, based on 3 decades of the DOJ. How many cases have you had? Think about it now. I know it's going to take you a long time to think about this mathematical equation. How many cases have you had where there's physical evidence at the scene of a homicide case, or any other case for that matter, in which the question is who was in possession of that bottle, the victim or the defendant, that you said in an evidence review, forget the DNA? How many? Take your time.
Zero. Okay, and let me tell you something. Even if this were not a homicide or where you have a death, even in a regular case, you would want to have the DNA checked of the cup and the bottle. And did they find out whose blood it was? I got to tell you this, going back to your question about should a defendant take the stand, no way, no how.
Right.
There's so much reason
Yeah, and I
Yeah.
see Linda is shaking
Yeah,
her
he
head.
testified already. He
Yeah.
testified through a statement.
Yeah, and he's got a statement in there, but moreover, I think it's the lack of evidence. I think all of us agree, great question again by one of our chatters, that we would advise the client. Of course, the client makes the ultimate decision not to testify because there are so many holes in this case, and the judge will give an instruction that the defense doesn't even have to put a case on, not to mention the fact they can't hold anything against the defendant for not testifying. And guys, one last thing I'm just going to say real quick. You've had it happen. You review a case, hey, things get missed. You could have thousands of pieces of evidence. I've tried murder cases with thousands of pieces of evidence. One in particular, right in the middle of the cross-examination of the defendant himself, I didn't even recognize the value of a piece of evidence that was overlooked until he was actually testifying. But you go back, and remember, this is the second trial. You go back and you try to do what you need to do. You could always have that stuff tested. Would you do that as the prosecutor?
Yes, in the middle. I've had cases in the middle of trial when I was a prosecutor. Now, we didn't have DNA back then, but yes, you go back and say, hey, wait a second, I need this investigated, I need this testing in the middle of the trial.
Right. You may get grief get grief for that, but the bottom line is the jury is just not going to accept this. It's going to look really bad. Let's go to the cross-examination of this officer. We'll be back on the other end. We are on a short leash before we have to go. Linda, I'm asking for one adjective to describe what happened to the state's witnesses through the defense cross-examination in this case.
The answer said it all. This is grass here, right?
That says it all, Gene Rossi.
Embarrassed.
Yeah, I'd say sad. Hey guys, listen, this is the Baptista trial. We really appreciate everybody here at the Long Crime Network, Linda and Gene, all our producers, everybody here, Dan for his great network that he has allows to do this. The great Jesse Weber's coming back for a repeat today. We'll see you next week.